This is the most disturbing video I've put out about court, and I've put out a lot of horrific stuff. But you're going to see a judge laugh and then apologize 3 times in a row to a litigant who is insisting that he have ADA access, and the judge won't give it to him. You're going to see an attorney stomping on this man's rights as well, and colluding with the judge to ignore the fact that this litigant needs ADA access. So, here we go.
Recording in progress.
Mute me on your end.
Well, good afternoon. I hope everyone had a Merry Christmas. I've initialized the quarter for our Zoom hearing in 19 DM 9325 in the matter of counsel. Your appearance for the record, please.
Patrick Blanchard on behalf of the respondent. The petitioner, who also appears today via Zoom, Your Honor.
Thank you. And would you please say your name for the record?
I do not have ADA access.
Mr.
I do not have ADA access.
I'm not sure what that means. Could you please elaborate for me, sir?
Judge, this is Jay Shore. I'm a certified Americans with Disabilities Act advocate. You're fully aware of what that means because you have an email that you referred to in the last hearing. And it's time for you to perform an ex parte hearing so he can have ADA access and stop bringing this out into open court, which is a violation of the ADA, and you're aware of that as well.
Your Honor, I'm going to object. Mr. Shore is not a licensed attorney in the state of Kansas or anywhere else. He shouldn't be speaking for Mr.
I think he was trying to provide some explanation. Well, I'm honestly at a loss of trying to figure out how to put this accommodation in place if Mr. isn't aware of the services that are provided. Ms. Piles, what services were you contracted to provide for this matter? I mean, Ms. Piles.
Excuse me?
So, Ms. Piles, tell me about the services you provide for the ADA request. It is basically a transcription of the court hearings. We can read it.
Correct. It's just as if it were captioned on TV. There's
and
no
I would presume that we have to provide Mr.
Under 28 CFR 35.160B2, you're prohibited from bringing this into open court. You have to provide privacy for Mr. And you're dragging this out into open court and allowing Mr. Blanchard to attack Mr. on the basis of disability. This is on you, Judge. You need to have an ex parte hearing concerning this.
Your Honor, that's not what the statute says. The statute says that it's an informal hearing. That's all it says. Nothing about ex parte.
Well, given the person's experience in saying ex parte, I'm going to take that for what it is. So, Mr. Can you provide us with an email so that link can be sent to you, please?
I need more than CART to have ADA access, and you know this.
And I'm trying to define what that service you're requesting is.
Judge, 42 U.S. Code 12203 says it's unlawful to coerce, intimidate, threaten, or interfere with ADA rights. And you're doing that right now. It's unlawful for you to do that.
Judge, I'm going to continue to object. He's not a licensed attorney in the state of Kansas. He doesn't represent Mr. He needs to speak for himself.
Mr. does not have administrative access to this court, and it has nothing to do with arguing in court. Mr. is being barred from access to this court through the ADA because Judge Journey is denying him that access and intimidating him and coercing him and threatening him under open court. So, I mean, I don't have to be an attorney to assert that he does not have administrative access in this court, period. You can object.
Making legal arguments, Your Honor, so I still object.
Well, practicing law without a license, there's a number of ways it's defined, including the rules of this court, which he's talking to me about how the rules of this court should be applied in this case.
If you want to testify on the record that I'm practicing law without a license by advocating for my client, I'm happy to cross-examine that.
Judge, you don't get cross-examined, obviously. I'm telling you something that's...
If I'm going to be accused, I'm going to cross-examine my accuser. I have a right to do that.
You have no right to speak at this hearing, period.
I would tend to agree. The court rules regarding ADA access and the statutes appear to be quite clear that that kind of request has to be made before the hearing.
Was made before the hearing.
The request was not made. I'm sorry, don't interrupt me again, sir.
It was made before the hearing.
I'm sorry, sir, don't interrupt me again.
It was made before the hearing.
And while that request was made contemporaneous with our previous hearing, there was no request in the record, either by counsel or by the respondent, in any form until that day after he fired counsel. That was when this court was placed on notice that there was an issue that needed to be addressed. And I would like to be able to address that issue. But it's difficult to find an accommodation when there's little or no description of what that accommodation needs to be other than what we've already provided, which is the interpretive services. So he has something to read. Help his concentration, I suppose. Mr. Would you like to address your motion to stay these proceedings today?
I do not have ADA access.
Would you like to address your motion to stay the proceeding pending appeal with your memorandum of points and authority?
Again, I do not have ADA access.
The generality of your request is impossible to comply with.
Are you saying that you're incompetent to give him ADA access to this court, Judge?
You're done.
Now, just a few days earlier, Philip Journey said this.
I do not have ADA access to the court.
Mr. We're going to get it for you.
What's coming next is the most blatant display of judicial terrorism against a person with disabilities trying to get access to the court that I've seen in my 5 years of doing this. On December 27th, Judge Journey decided just to ignore that my client needed ADA access. They brought in a CART interpreter, which was one of the accommodations we'd asked for, but there were about 10, and we needed all of them. And they brought in a CART interpreter and acted like they had fulfilled all of their obligations. And Judge Journey had read the email, seen the email. It was presented to him during this 27th hearing in November. And he's acting like he doesn't know what to do. When he does know what to do, he knows that he has to have a private conversation and keep this private. And instead, he's going publicly in court, ignoring that my client needs ADA access. My client's getting agitated, asking why. You're going to see what happens here. This is absolutely jaw-dropping.
Right. And then there were provisions in your original proposal
Why are we continuing the court when I don't have ADA access?
not addressed.
Your Honor, I had originally journalized.
Perhaps you'll remember Mr. Blanchard from the last hearing that I publicized here, but he's the one who actually accused my client of asking for ADA accommodations to harm the opposing party.
All this is just a way to harm Miss. It's an intentional act on Mr. part to try to harm her, and I think that's reprehensible.
It's my belief that these two are colluding and conspiring to deprive my client of ADA rights and intimidating, coercing, threatening, and interfering with his ADA rights. But this is the icing on the cake.
So why do we not have ADA access when I've asked for it? Why is this court continuing to go on without access?
Your Honor, to answer your question, I did that. Plus, I put together.
Why is this court continuing to happen even though ADA access has not been met, Judge?
Your Honor, the final division of asset and debt was not handled in your Lily.
Mr. Journey, why are you continuing to let this go on without ADA access?
I don't know what your ADA access requires. We've provided services for you that you've not taken advantage of.
Put me on speakerphone.
Speakerphone.
I don't know why.
That's because you have refused to give him ADA access in an ex parte hearing and allow
There
him
is
to
legal
explain
advice
to you
from
what
his
he
helper
needs.
there.
And you have an email from Joni Wilson explaining all of this.
Are you laughing at this, Judge?
I'm sorry. I get him. Okay. So,
Are you laughing because I've asked for accommodations that have not been met?
because of my circumstances, no, you're.
This guy right here is everything that's wrong with the American justice system. Your Honor, no, not at all. This is what people face on a daily basis going into court. They face punks like Philip Journey, who don't care about justice, who only care about a paycheck and an ego. And they laugh when people insist that they have ADA rights. They laugh. We happen to catch this one on tape. This guy needs to be made an example of by the Kansas Judicial Commission. And believe me, we're going to try to make that happen. Not only that, but we're going into federal court with this guy. Because 42 U.S. Code 12202 removes immunity from him for ADA violations. And everything you just saw has been going on. So, this is why we need more ADA advocates. People like this kind of punk right here that sits on the bench and operates behind a robe and a title of Your Honor while he's stomping on the rights of individuals who come before him that need equal access. And he colludes with a lawyer, the opposing lawyer in this case, to affect that. I mean, they were sitting there ignoring that this guy needed ADA access. And when Blanchard did respond, he said that my client was asking for ADA access to harm the opposing party. And it was reprehensible. All of this ADA rights access stuff is just a way to harm my client, and it's reprehensible. You know, this is the worst case that I've been able to publicize, but this goes on every day. Spread this around like wildfire, please.